May it please the court. Tony Duncan of the Nashville Bar. I represent Ms. Campbell in this appeal. This time I'd like to reserve 4 minutes for rebuttal.
4 minutes, yes, sir.
Before I begin, does the court have any questions, or does the court have anything they'd like for me to delve into initially? All right, so Ms. Campbell is asking this court for a new trial, to grant her a new trial, for 3 reasons. One is a clear violation of the collateral source rule as recently affirmed for personal injury cases in Dedman, which follows the restatement section of torts, section 920A, asking for a new trial based upon, this is the second reason, highly improper conduct by defense counsel during the trial. And third, for based upon the cumulative effect of both of those errors. And I'll address each one of them in turn. So under Rule 36D of the Rules of Appellate Procedure, we have to have an error, and it has to affect a substantial right, or has to involve a substantial right that more probably than not affects the judgment, or be prejudicial to the judicial process. So this first error is affected the judgment. So in Dedman, the Tennessee Supreme Court recently affirmed the common law collateral source rule. Under the collateral source rule, in it, this is a part that has been somewhat maddening to me, is that there's a substantive component to it, but there's also the evidentiary component. And the evidentiary component says that any sort of evidence of a collateral source, which this is under section 920A of the restatement, comment C2, it's an employment benefit. It's truly a collateral source. So that's not an issue. And it came in at trial, despite a motion in limine being unopposed and filed before. And something occurred to me last night when I was looking through the record at the pretrial conference. I'd also filed a motion in limine to obtain rulings upon objections made during Ms. Campbell's deposition. The trial court, and this is in the record, the trial court took that under advisement but never ruled on it. I would submit that if the trial court had done that, we probably wouldn't be here on this issue. But, so at the trial, so despite 2 motions in limine being filed, one prohibiting any collateral source evidence from coming in under Dedman, which was again unopposed and granted, and the other was one allowing Ms. Campbell to testify about her lost earnings, which she's qualified to do under the Tennessee Rules of Evidence. Again, that was unopposed.
Counsel, in terms of the prejudice or lack of prejudice, depending on which side of the podium you're on, and what our opposing counsel is going to say it's not, this never got to damages. So how is there prejudice in this case with regard to this evidence coming in? And it goes to, and if we're talking about whether her compensation related to her leave, her medical leave at 66% and on, but if we never got to damages, how is this prejudicial?
And here's why. And so the Tennessee Supreme Court in Dedman, page 444 for the record of Dedman, and it reads in part, the collateral source rule excludes evidence of other compensation on the theory that such evidence would affect the jury's judgment unfavorably to the plaintiff on the issues of liability and damages. And so the prejudice there is, first off, imagine, well, not imagine this happened. So we got the rulings on the motions in limine. Any conscientious trial lawyer is going to prep your client saying, hey, look, we've got a ruling on this. This is not coming in. So she's there from out of town, in front of the jury. The whole room is focused upon her. Her lawyer, based upon the trial court's ruling, told her, this stuff will never come in. Don't worry about it. It's a violation of the collateral source rule. And when she gets asked about that, everyone in that courtroom, the whole focus, the onus was on her. And it was just like ink getting dropped into a cup of water. I know this may be cliche, but it's drip, drip, drip. That got put up on the Elmo. which means it's on a big, huge flat screen, 80-some-odd-inch flat screen in front of the jury. So when I stand up to object, I ask Ms. Parks to take it off film. She does. Then the trial court overrules my objection based upon a clear collateral source. And not so, the prejudice would come in is she's painted, not only is she painted to look like a liar, and she's got this look of surprise on her face, but now the jury believes that this is good evidence coming in. This is totally unfair. So the prejudice there is she was, to use an idiom from back home, she got waylaid. So, but
Counsel, this court, it's an older case here, but Asheville v. Franklin, 1967 decision where evidence came in related to sick benefits, published case of this court. The court drew a distinction in terms of actions in which the collateral source evidence went to the direct issue of liability versus when it goes essentially to damages in the case. This seems to be a pretty close fit here to the circumstances. Is the variance between the two dependent, in your view, on the appearance of the witness here, in terms of you're saying she looked untrustworthy to the jury? Is that the critical component? Or I mean, I'm not. No. I mean, Asheville there may be some other difference between the two, but
that's a pre-Dedman case. So the Tennessee Supreme Court. So I remember when I was a younger lawyer, I ran into, during the convention, got on an elevator with Justices Drewota and Phones. And Justice Phones reminded me about Barger versus Brock. And it talks about our constitutional hierarchy and how, and I'm fighting a sneeze, I'm sorry, how the Tennessee Supreme Court is, and he quotes Carruthers' History of a Lawsuit, which should be kind of the primer everybody read, that Tennessee Supreme Court is supreme in name and fact. So I say that because it takes back, we've got a clear pronouncement in Dedman. And Dedman says this doesn't come in. There's no exception for it. I believe the trial court was mistaken. It was trying to treat it like a defendant's liability insurance information, which there's exceptions for that under Rule 411 of the Tennessee Rules of Evidence. Matter of fact, I wrote the amicus brief for the Trial Lawyers Association in the case Thomas versus Oldfield, which is a 2009 Tennessee Supreme Court case that talks about that whether or not that comes in or not. And we're the only state in the country, in the union, in state court, not federal court, where that doesn't come in automatically, defendant's liability insurance information. But if it does come in, there's certain exceptions for that control, agency, bias. The Supreme Court, in their pronouncement, as supreme in name and fact, made no exception for the introduction of this evidence. It says more than once in Dedman that this information doesn't come in.
Is it automatic reversal then? And collateral source comes in, and it's either mistrial or reversal if you have a defense verdict in that case?
I think if the defense plays that card now after Dedman, yes. Because I mean, otherwise, what are you going to do? You're going to say the Supreme Court's ruling in Dedman is watered down, or somehow when it's not qualified like that in the opinion. The text of the opinion doesn't say that. The text of the opinion is quite clear. It says it doesn't come in. I'm running out of time a little bit. So to the second issue, improper conduct by defense counsel. During the trial, defense counsel likened Ms. Campbell's claim to, or told the jury that she was wanting to be a lawsuit lottery winner, or words to that effect. That's entirely improper.
Wasn't there a curative instruction here though that was given, and a curative instruction that you agreed to essentially in this case?
At my behest the next day. And if you read the transcript too, the trial court just kind of wanted to pass through that and act like it was not a big thing. And I did object to it, but it's our position that that's so flagrant that an objection doesn't even have to be made under the Brady case, under State versus Banks. When something is so flagrant, and here's why, there's no valid reason to ever introduce that in front of a jury, ever. As Schoen versus Luby, which I understand is a South Dakota case, but it's on point, talks about how that demeans the process. It belittles what we do. The only reason someone would want to introduce that at trial is to inflame the passion of the jury.
Don't we presume, though, that the jury follows the instructions, and here there's a curative instruction telling them to disregard it, and doesn't that take care of, I mean, not saying that it should have been stated, not saying it wasn't an error to state it, but doesn't that solve the problem here in this case?
I would say no. Submit, and here's why. That's one of those things that's so bad that should never happen. And RPC 3.5 says that a lawyer should not try to influence a jury by any improper means. That's the law in Tennessee. And if I remember correctly, State versus Banks, which is a Tennessee Supreme Court case, says that some arguments are so flagrant that they require reversal. So yet again, to use my analogy here, that's just more ink in the water, more drops of ink. So by the end of this trial, that cup of water with the ink in it was as dark as a moonless night because of the combined effect of these errors. And that brings me to my third point. So even if this court were to find that the first error wasn't enough to warrant a new trial, and even if this court was of the mind that the second error wasn't enough to grant a new trial, when you combine those, when Mayo talks about that, Mayo versus Shine, the combined errors would be enough to grant a new trial under Rule 36B. I'm sorry. And my time is up. If the court has any questions, I'll yield the floor.
Don't see any questions.
All right,
Thank you.
May it please the court, my name is Miles Martindale. I represent the appellee TC Restaurant Group, LLC. A little housekeeping matter. So there are several issues before the court today that have been raised by the appellant. I will address the collateral source issue, and Mr. Dave Rich, on behalf of appellee Chris Broussard, will address the appellant's argument regarding the lottery lawsuit winner issue. Unless your honors request otherwise, I will address the court for the first 10 minutes and reserve the remaining 5 minutes for Mr. Rich's argument.
Okay.
I'll start by addressing the legal standard. A trial court's decision to deny a motion for a new trial is within its discretion, and such rulings are accorded great deference. As a result, the trial court's denial of a motion for a new trial is only overturned if the decision amounts to an abuse of discretion. An abuse of discretion only occurs when a court causes an injustice to the party challenging the decision by 1, applying the incorrect legal standard, which we don't have here, 2, reaching an illogical or unreasonable decision, or 3, basing its decision on a clearly erroneous assessment of the evidence. It's our position that none of these factors are present.
Counsel, the trial court did not concluded that no violation had occurred of collateral source rule, right? And in terms of denying the motion for a new trial, it's not that the judge said, well, the judge did get into sort of the effect, but makes an initial determination doesn't violate, right?
That's correct, Your Honor.
How is this not a violation of the collateral source rule in terms of the reference to medical leave and payment in connection with medical leave, and how does that not fit within the collateral source rule?
Your Honor, I think Judge Briley relied on the fact that the evidence, and really it was a reference, it wasn't true evidence as much as it was a reference to evidence that the plaintiff used as the basis for her lost wage claim. And I think that the reason the whole line of questions started in the first place is because under a direct examination, the plaintiff was simply asked, are you claiming lost wages in this case? Yes, $15,000. And that was about the extent of the questioning on that issue. And so there was no blackboard of calculation where she testified, well, I made this hourly wage, I missed X amount of days, a total of X number of hours, to really substantiate that. So I think the whole line of questioning on cross-examination was really about showing that, hey, there's some objective basis, even if we disagree, and you used an actual calculation, but you don't have that with you today, so you don't have anything you can point to.
Isn't there evidence being put before the jury, though, that she's asking to be compensated when she was getting paid at 66% rate for sort of her full salary for the time she wasn't working? And that evidence is going before the jury in this case. That's excuse me, something that she's seeking, and I'm still struggling to see how that doesn't fit within the scope of what's prohibited from an evidentiary basis under the collateral source rule.
I understand, Your Honor. What I think is important is that in this case there is no questioning of, so your total number is 15, but really we're talking about the missing 33% of that in employment wages. There's no questioning whatsoever about that. There's no argument that there should be any sort of reduction in her claimed $15,000 worth of damages. Frankly, the extent of the cross-examination is frankly pointing out that she hasn't done anything at trial to substantiate the figures. And so it's not so much that there's absolutely no argument in the record that the figure should be reduced because she received 66 cents on the dollar. The reference was really to her deposition testimony, where she referenced pay stubs that she was receiving while on medical leave to substantiate that time that she missed.
Does that go more into prejudice in term than whether it actually violates collateral source? And is the key question here prejudice, that it didn't prejudice rather than that it is or isn't a violation? I mean, if you're still taking the position that even if it is a violation, it's not a prejudicial error.
That's correct, Your Honor. I don't know that I would go so far as to say, just wholly accept that it is a violation, but I certainly would argue that even if there was an error, which we're claiming there isn't, it didn't prejudice the plaintiff anyway, because we do believe that damages are separate and apart from a liability assessment in this case. This isn't a case where I know that the appellant has really pointed out about credibility, but this is also a case where there was video footage of the incident that occurred. So the jury was able to see for themselves the incident. And so we believe that that's a factor that would frankly kind of undermine that the prejudice argument that appellant is putting forward.
Is there any reference in this case when you get to closing argument to the two improper, let's assume I understand you're saying it wasn't improper with regard to collateral source, but is there any reference to the medical leave payment or the lottery lawsuit comment in closing argument in this case?
Your Honor, you're testing my memory a little bit, but I don't recall any sort of reference in closing argument addressing those two items.
So the only time there references that one moment of cross-examination and then the statement in the opening statement to the lottery lawsuit? Correct,
Your Honor, and I do think that the order is the lottery lawsuit was made during opening statements, and then the cross-examination happened during trial. So that's the order, but as Your Honor pointed out, during the appellant's argument, there were curative instructions given to the jury on both issues, and we find that that's important, frankly, because as Mr. Rich will address, one of which was, both of which were consented to by the appellant, and so we feel that that would have cured any sort of prejudice that may have occurred. Again, frankly, the analysis is really boils down to Rule 12. Not only says that a final judgment from which relief is available and otherwise appropriate shall not be set aside unless, considering the whole record, error involving a substantial right more probably than not affected the judgment or would result in prejudice to the judicial process. What we find important is that in terms of getting to damages, which is really compensating the appellant for her lost wages, the jury never got to that point. On page 158 of the technical record is the jury verdict form that was returned by the jury, And it says, do you find the defendant, Chris Buffard, to be at fault? Plaintiff Tatum Campbell has the burden. Answer, no. So there's no real damages analysis. There's no potential reduction of damages that the appellant can point to say, see, this comment shows that they reduced my client's, let's say for sake of argument, that they would have found in favor of the appellant and there was liability and then reduced those damages by 2/3, then I think you would have some evidence to point to say, look, I think there were some prejudice in terms of what was awarded to my client in the form of a judgment. We don't have that here. On the front end of liability analysis, the jury determined the defendants weren't at fault.
Perhaps I misheard, but didn't Mr. Duncan suggest that the Devon case also said that affected liability as well?
He did, Your Honor. And here's how I would respond to that. As when a lawsuit is filed, I think a jury wants to make sure that justice is done. And when they know that money has been paid out, in the traditional sense, it's usually in the form of medical bills in a personal injury case, that, hey, they're only out of pocket $5,000 as opposed to the $75,000 that they've boarded in what is the total cost, then they may be less likely to give those in damages, or it may affect their liability analysis knowing that, hey, this person really isn't out that much money. Here, there's no evidence that any reduction was argued or that any actual evidence was entered showing that, hey, she received X amount of dollars under these medical leave benefits. So it's our position that that's just simply not present in this case. I'll conclude briefly just to say that the trial court did not abuse its discretion by allowing the introduction of this deposition testimony about how the plaintiff appellant calculated her wages. The trial judge gave a curative instruction to the jury on that issue, but more importantly, the jury decided that the defendants were not at fault. There's no judgment to offset or reduce under the collateral source rule. Accordingly, the appellant cannot show the error more probably than not affected the judgment because the jury's finding with respect to fault was none. On behalf of the appellee, I ask that you uphold the trial court's decision, and I will yield the rest of my time to Mr. Rich.
Thank you.
Thank you.
May it please the court, good afternoon. I'm Dave Rich, and I rise today on behalf of appellee Chris Bullard, who was the band leader who was sued in this case by the plaintiff under an independent allegation that the band leader was somehow liable for plaintiff's injuries and falling off the stage drunk. So the part in my presentation focuses on my words, my probably best not the best choice of words that I used during my extemporaneous opening. Specifically, this exuberant utterance that I talk about is I stated to the jury that, in effect, Ms. Campbell's lawsuit was so frivolous that it amounted to a lottery lawsuit. Now, I can acknowledge that that was not the right words to use, and I did so as well in front of the court. But to say today that that's somehow that specific statement made during an opening statement that was then cured by the court and the curative instruction was accepted wholesale by the appellant, that should somehow allow Ms. Campbell another bite at the apple to get another chance to argue this case in front of a jury just lacks merit.
Spencer, was there any subsequent reference, and did you come back to, is there any sort of continuing reference beyond that first statement in the first utterance during your opening statement in this case?
There was not, Your Honor. And again, I was trying to demonstrate that my client's case was that Ms. Campbell's case was frivolous. And the trial court acknowledged, and I think the appellant acknowledged, that we can call cases frivolous if that truly is our client's case. Our client lives and dies on that argument. If a jury says they're just willy-nilly calling things frivolous, but there's real facts underlying the case, that makes your argument look less credible in the jury's eyes. So in this case, a repeated touchstone of Mr. Bullard's defense was how frivolous Ms. Campbell's case was. First and foremost, you don't often see a band leader get sued for a drunk patron that tries to get on the stage and then falls off the stage and gets injured in the process. You also don't see a band leader get sued when there's a videotape of the actual fall. And then thirdly, you don't see a band leader get sued when a plaintiff is claiming an injury and says it was so hard on me, I was so injured by this accident that I couldn't go to work, I was having headaches, I couldn't go outside of a dark room. And then we see TikTok videos where she's imitating a horse and she's doing all of these other things. The case was frivolous. The jury found that way. And my statement of a lottery lawsuit had nothing to do with the jury's finding. The jury was able to evaluate the evidence, see a drunken girl who did not make any claim against the bar that the bar had somehow improperly and served her to the point of intoxication. The allegation was only that the bar was liable for A, not posting better notices that patrons can't get up on the stage, and in the alternative that my client, the band leader, was somehow negligent because he came to her aid to, I guess, stop her from falling and didn't do a good enough job rendering that aid, and she fell off the stage. It was a frivolous case. The case law that I cite in the brief, specifically the Bradley versus Bishop case found at 538 Southwest 3rd, and the Teague versus Kidd case, which is a 2017 Court of Appeals case found at Lexus 351, it was not reported, finds that two things, that A, a judge can issue a curative instruction to correct excited or exuberant utterances like this one in this case, and that in order for there to be a real error or something that causes a reversible error, it has to be persistent. And in this case, just as Your Honor recognizes, it was not persistent. This was a singular event that occurred during my opening statement, which is not evidence. And so we would respectfully request that the court not look at this as counsel alluded to, because he used the word introduction. This was introduced into the record. As Your Honors know, the arguments of counsel, no matter how impassioned they are, do not amount to evidence. Evidence comes from witnesses. And so in this case, the opening statement, that utterance, is not grounds for reversal. It was not persistent. And finally, the plaintiff, the appellant in this case, waived any objection by saying, I accept this curative instruction has addressed the problem. And that's what happened in this case. So in effect, even if the court found that somehow this utterance did somehow, it was wrong or it shouldn't have been said, it still, in the end, there was a waiver by the appellant to that objection, and it was not maintained. If Your Honors have any questions for me, I'd be happy to answer them. Thank you. That's all my time.
Thank you. Mr. Duncan?
Yes, Your Honor. A few things. There's nothing in the record about my client being drunk. She was there for her birthday with her mother. And yes, she had some alcohol, and she was of age, which everybody downtown of age does. And so they keep trying to paint her as she was not intoxicated. And you know how you get rid of a frivolous case? You file a motion for summary judgment. That was never done here. Was never done. You know why? Because they couldn't do it. And so now they're going to call it frivolous? I object. I reject that argument.
Counsel, you noted banks, State v. Banks,
Correct.
in terms of a statement, and there are things like, for example, a prosecutor referencing a defendant not testifying that you just can't unring. Is the distance between the distance between lottery and frivolous really so great that that's? Because if opposing counsel can call it a frivolous suit, and I know you disagree and you say that's wrong, but if you can call it a frivolous suit, is it really doing that much injury that it's tantamount to something like a prosecutor saying, hey, you better watch and see if this defendant testifies here in this case, because I don't think he's going to take the stand, and boy, if it was me, I'd get up there. Aren't those two different really places to be in terms of the nature of the harm that's potentially caused by an opening statement.
I would submit that this was an excited utterance, and what he said was so wrong, it should not happen. It's entirely improper, and Shune versus Luby on page 891 does a very good job of explaining that, how it demeans the process of what we do. That it's not an excited utterance. There's no valid reason for that to have been said, ever, except there is a reason: to inflame the passion of the jury. Because liking it, now frivolous, I grant you, was close, and we had a kind of a knockdown drag out over that with the trial, and it's in the record with Judge Briley, whether or not they could even use that adjective. But the lottery lawsuit comment is, again, there's no valid reason for it. There's no, that alone ought to be, based upon Shune versus Luby, that alone ought to be grounds for mistrial. But then you couple that with the clear violation of the collateral source rule. I mean, this is clearly a collateral source issue, and the Tennessee Supreme Court in Dedmon makes no distinction about whether or not there was prejudice or not. It just doesn't come in, writ large. And what's even...
Doesn't there have to be prejudice for it to be reversible error? And
I think under Dedmon doesn't say, Dedmon just says it doesn't come in.
Well,
and if it comes in, and here's why this is so
error.
bad. This is why there is here's why there's prejudice, why this is so bad. Under the preamble of the rules of professional conduct, lawyers are supposed to know the law. They're supposed to be experts. We had motions in limine at the pretrial that were unopposed on the collateral source issue. And also, they're talking about Ms. Campbell testifying about her lost earnings. Under Rule 701B of the Tennessee Rules of Evidence, she has a right to do that. Now it's the subject of one motion in limine also. Their time for saying this is unsubstantiated or any sort of objection should have been then at the pretrial, and they didn't do it. So, but even though Dedmon doesn't speak of terms of prejudice, there's prejudice here. Whether or not, and the thing about it is going back to the ink in the cup. So while that's on the Elmo, Ms. Parks is asking my client about that. It's only a 2-day trial. It wasn't like it's a week-long mid-mal trial or a month-long. This is like, every time she's talking to her about that, and that's up on the Elmo for them to see on a huge flat screen, an 80-something inch flat screen. Just drip, 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 more ink in water. You couple that with the lottery lawsuit winner comment, which is entirely improper, and those combined errors were so prejudicial that they warrant a new trial. And that's what Ms. Campbell's asking this court to do under Rule 36B. Thank you.
Thank you. Thank you both, or all three of you, actually. I believe that concludes the docket today. So if you will please adjourn court.